All right, you can go ahead and call the case.
All right, thank you. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re A.K., case number 25-AP276. Representing the appellant, S.K., is attorney Carrie Johnson. Representing the appellee, the state of Vermont, is attorney Zachary Martin.
Good morning, counsel. We'll hear from the appellant first, of course. Please introduce yourself and your client and then proceed.
Good morning, Your Honors. My name is Carrie Johnson, and I am representing the appellant father, S.K.
Thank you.
S.K. is a loving father who served as his daughter's primary caregiver for the first half of her life. And the court found that both children have a strong bond with their father, and that bond remains in place today. Before that bond can be permanently severed, the law places the burden on the state to prove by clear and convincing evidence that the parent's progress has stagnated and that termination is in the children's best interests. The state failed to meet that burden here, and therefore this court should reverse. At the first termination hearing, almost all the evidence that was relevant to the threshold issue of whether there had been a substantial change in material circumstances was hearsay. DCF failed to call any witnesses that had firsthand knowledge of father's progress in completing the action steps contained in his case plan. And the evidence offered by the state at that hearing was plainly insufficient to support the termination of father's parental rights. The court essentially said as much from the bench. Therefore, it should have granted father's motion for judgment as a matter of law. The court denied that motion not based on the merits of the motion, but on its erroneous belief that such motions were not permissible in termination hearings. Both parties agree that those motions are permissible, and therefore it would have been proper for the court to deny DCF's termination petition at that time. However, instead of denying the petition, the court reopened the evidence after telling the state exactly what evidence was missing from its case. At the second termination hearing, the state introduced non-hearsay evidence concerning a single incident that occurred more than 6 months before the termination hearing. And it introduced some additional evidence regarding parent-child contact. However, it never established how many visits were attended or missed, and provided very little, the testimony provided very little detail about the quality of those visits. And despite this additional evidence that the state was given a chance to introduce, it still did not prove that SK stagnated in his progress toward reunification. The evidence showed that father was making progress consistently beginning in the second half of 2024, and that progress continued through the first half of 2025, and that the evidence showed that father substantially completed all of his action steps. Importantly, however, father didn't have the burden of proving that he completed his action steps. The state had the burden of proving that he didn't, and it utterly failed to meet that burden here, and therefore the termination of father's parental rights cannot stand. Unless the court has any questions, I'd like to reserve my remaining time for rebuttal.
Okay, that's fine. Thank you. I don't see any hands, so we'll turn to counsel for the appellee. Please start by introducing yourself and your client and then proceed.
Good morning, Your Honors. My name is Zach Martin, and I represent the Vermont Department for Children and Families in this case. During cross-examination at the March 21st, 2025 hearing, father's counsel repeatedly referenced the testimony that he intended to present. That's in the transcript at pages 46, 51, 52, and 53. The attorney for the children relied on those representations, and when father did not call any witnesses, move to reopen. The trial court's grant of the motion to reopen was within its discretion and should be affirmed. And this court should also affirm the ultimate termination of father's parental rights.
What do you say about the argument here that procedurally what the court did was to provide a roadmap for DCF as to what was necessary and missing in the evidence?
Thank you, Your Honor. I think there are a few different ways to read the court's comments that it made in ruling on the denial of father's motion for a directed verdict, which I believe is what the court is referring to. So if you look at the transcript, this is the March 21st, 2025 transcript at pages 103 and 104. The trial court essentially said, I'm not going to grant the motion for a directed verdict, but it sort of verbally was processing and commenting on the evidence and said, I'll consider all the evidence under the clear and convincing standard. And at that point, father had not yet indicated whether he was going to call any witnesses or present any evidence. The evidence remained open. To the extent that father's motion for a directed verdict can be construed as a motion for judgment on partial findings under Rule 52C, I want to emphasize that Rule 52C uses the permissive may. The court may enter judgment, or the court may decline to render any judgment until the close of all the evidence. So one could read the court's comments in the transcript as essentially selecting the second option contemplated by the rule. I do not think it was the court's intent to provide father or the children with a roadmap. However, what I will say is that there is authority for the court to take an active role in termination hearings. The disposition hearing statute, 33 VSA 5317E in particular, contemplates that on the court's own motion or the motion of a party, it may schedule a further hearing to obtain reports or other information necessary for the appropriate disposition of the case. This court most often cites subsection 5317B of the disposition hearing statute in its termination cases, which relates to the propriety of admitting and relying on hearsay. But this court has also recognized that a post-disposition termination hearing is in the nature of a further disposition hearing. That's as far back as 1989. The case citation is In Re CL. That's 151 Vermont 480 at Penn Sites 486 through 487. The Atlantic citation is 563 Atlantic 2nd 241. I would also say that there is persuasive case law to support the course of action that the court took here. First, there's the decision of the Alaska Supreme Court case, which the trial court cited in granting the motion to reopen of In Re Journée N. In that case, the Alaska Supreme Court considered a similar circumstance to what happened here. There, the trial court first invited and then granted the state's motion to reopen the evidence at TPR. And in affirming that decision, the Alaska Supreme Court noted that in a termination trial, the rules shouldn't be applied rigidly. They should be applied to achieve a just and accurate outcome. And further held that the extreme importance of complete information in making a fully informed judgment even outweighed the state's lack of diligence. And it further found no abuse of discretion in the trial court's decision to reopen and no disqualifying judicial bias. And in rejecting the parents' argument that the court's invitation of and grant of the motion to reopen violated the parents' due process, it emphasized that providing all parties the opportunity to present more evidence, to present a fuller picture of the facts to the court, would not increase the risk of any erroneous deprivation of rights. And the same is true here. After granting the motion to reopen, both the children and father had an opportunity to and did present extensive additional testimony. Finally, there's the Razmilovich case. The court in that case, and this is at Penn Sites 30 through 31, made the point that although Rule 50's notice and opportunity to cure provisions don't directly apply in a bench trial, a court in the context of a bench trial has no less authority than it does at a jury trial to allow a party to attempt to cure an alleged deficiency in its proof. And given the similarities procedurally between that case, I see I'm out of time. I thank you for your time, and I would respectfully ask that you affirm the judgment below. Thank you.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 21 seconds remaining.
Counsel?
Thank you. In response to the appellee's arguments, I would like to point out that the evidence was closed at the point that this motion for judgment was made. The state had rested its case and the children had rested, and the and father decided to rest his evidence, I believe right after the lunch break. So all of the parties other than father had rested at that point in time. And again, the court only denied the motion because it didn't believe that it had the authority to take that action at that time. It was not using its discretion in any way because it didn't think it had the authority to do that. And I also think that the appearance of fairness and propriety is vitally important in these cases. And this case on its face did not appear fair. The court told DCF it wanted information about this incident in December of 2024 specifically. And then it got that evidence, and that was pretty much the extent of the unhelpful or negative towards father evidence that was introduced at the second hearing. Most of the evidence, the vast majority of it, was positive
Okay.
toward father.
Okay.